Ask an attorney about Florida law. Ask an attorney, just give him a call.
This is Ask an Attorney, all about Florida law with Attorney Joe Pippen. If you have a legal question, call Joe right now. In Tampa, call 813-287-5700. Anywhere else, toll free at 877-943-9673. That's 877-943-9673. The law office is open. And now your host, Joe Pippen.
Hey, good morning. Welcome to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. Happy 4th of July. And yes, we are doing a live show today. If you have a legal question, all you have to do on this Independence Day, 4th of July, 2020, is give us a call. Love to talk to you today. 87. When you come in on a holiday, you never really know how many calls you're going to get. You think people might be listening, but they have a lot of other things they might be doing, getting ready for cookouts and family time together and so forth. But hey, I'm here. Ask an Attorney, all about Florida law, longest running radio show in Florida, 36 years now. I'd love to talk to you on this 4th of July. 877 is the toll-free number, 877-943-9673. That's 877-943-9673. Phone lines are open. In fact, we have a caller already. Let's go to Russ in St. Petersburg. Hey, Russ.
Hey, happy 4th, Joe.
Happy 4th.
Thank you for all the good work that you do.
Thank you.
A couple of questions. My mom's in the nursing home, and I don't think we got as a beneficiary on her IRA or her condo, but we did on her checking account. So a couple of quick questions. What happens with the no beneficiary, or I'm not on it as her IRA or small IRA or her condo? What happens there? Is it probate or
yes.
something?
Now, let me say it would be unusual to not have a beneficiary on a retirement account. So the financial advisor or financial company that set that up would have really been remiss in not helping get that accomplished.
Yes.
So,
but that will still go through probate.
That would go through probate if you don't have one.
Okay. And
now the condo, we could do, Mom could do a living trust to put the trust into the condo into a trust to avoid probate. There are several ways to do that, but I think a trust is maybe the better way. What, is she in a local nursing home?
Yeah, it's a little late for that. She's not very cognizant, and she's in a local nursing home, rehab center, and it's, I think, past the fact here. And
so she wouldn't be competent to sign a legal document?
The odds are no.
Okay.
Not at this time.
Yeah, we've been able to go to a few nursing homes and stand outside a glass door, glass window with our client in the lobby of the nursing home, and get some things signed if they're competent to sign documents. If
they're competent, right. Yeah,
so if they're competent. If they're not competent, that's a whole other issue. You might have waited too late. Yeah, but do you have her power of attorney? Sometimes you can use the power of attorney to create a trust.
I am her power of attorney.
Well, we have to review the power of attorney to see if it grants that power. So there might still be a way to avoid probate.
Oh, okay. That's very good information. And the other part was about gift taxing. Is when you say that, I think it's $15,000. If she does a gift tax to me and my sister, is that considered income to us?
No, it's no income to you, and she could avoid the gift tax because you have $11.5 million exemption before there's any tax due. And she could fill out a 709 gift tax return and just sign it and say that she gave more than 15 but wants to use up part of her lifetime exemption.
Okay. So all I do is get with you to see how I can use the power of attorney to get by probate.
Yeah, I'd be glad to review the power of attorney. We don't charge for that, and I can tell you whether you can use it to create a trust.
Awesome. Thank you, my friend.
All right, thank you. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. 4th of July. Happy Independence Day. You have a toll-free number. Love to talk to you at 877-943-9673. Let's go to Phil, calling from from Jacksonville area. Hey, Phil.
Good morning, Joe Pippen and staff. From myself and the Northeast Florida folks, we want to wish you a very, very happy Independence Day and a safe one, and I don't have a question. I just want to thank you for all the good you do every day, and the shirts came out beautiful. I'll get with you on that.
All right. Hey,
okay,
I'll be in Jacksonville this coming week.
Oh, wow, great. Okay, I'll give you.
I'll be there Thursday and Friday this week.
Okay.
Yeah, you had said you were going to come by and see me about an amendment for somebody or yourself. I forget,
yes,
but I'll be in town
this.
this coming weekend.
Friday at your office. Okay, thank you.
All right, Phil. A happy Independence Day to you, and thanks so much for calling. All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open. 8 o'clock on Independence Day, we're open. Yes, we are. Trying to help you if you have a legal question. Your question can be just about any area of law. It can be about wills, trust, probate, guardianship, family law. It can be traffic accidents, traffic tickets, real estate. It can be just about any area of law. It can be about Medicaid planning. Can be just about any. I should have asked Russ about Medicaid, because a lot of times you can use a power of attorney to shift things around a little bit and almost instantly qualify for the Medicaid process. And that's not, even though you have an IRA and a condo and some other assets, you might be all in line to qualify for Medicaid. It's just the art of positioning assets, moving assets around a little bit. And sometimes even if you're on a private pay situation, thinking you have to spend all of your money down to qualify for Medicaid, sometimes things can be repositioned to so you do qualify and maximize what you can obtain from government benefits and maximize what you can save as your legacy for your family. Hey, I'm Attorney Joe Pippen. Phone lines are open. You have a toll-free number you can call at 877-943-9673. That's 877. Phone lines are open at 943-9673. Had a lot of interesting questions about masks here lately, and whether if you're a disabled person where wearing a mask would be detrimental to your health. Do you have any special rights, like entering into a store and maybe not wearing a mask? I think the answer is to that the store owner has the duty, let's say, to accommodate you in maybe some other way, but the store owner does not have a duty to have to let you into the store if you cannot wear a mask. So if you have questions about that, we can talk about that. It's a very interesting new body of law that seems to be emerging on the right not to wear a mask for some people who don't want them or can't do them. And so they have a doctor's note they can't wear a mask for some health reason. It will be harmful to their health, and they're a disabled person. Under the Disabilities Act, do they have the right to come into your store? I would say no. The store owner has the duty to accommodate you in some other way, but they don't have to. The overall general health issue, they don't have to let you in to their store, but they do need to accommodate you. All right, let's go to Debbie in Tampa. Hey, Debbie.
Hello. I had a question regarding setting up a trust. My mother has a will right now. My father just passed away in April. Mm-hmm. And they both had a will. I am the power of attorney. Of course, she has an IRA. She has a home, which is paid for, and I am her caregiver. But my thinking is, should I have done a trust for her home instead of a will to keep it out of probate? There's 4 other siblings, and everything will be split equally when she passes. But
well, when
right
you die
now,
with a will, and you die with an asset just in your name. So if your mom died with a condo just in her name, there would be a probate process called petition to determine homestead through the probate court. The minimum fee that we charge for probate is $2,500 plus cost. They're $400 or $500 or a little bit more in cost. So you got a $3,000 bill there to transfer the home. If you did a living trust, you could avoid that completely, plus you can put other assets in the trust to avoid probate. So, yeah, a trust might have been a better idea if you want to save money, make it quicker or easier and faster to be able to transfer the home. And
what is the cost of a trust?
Well, we have flat fees. Excuse me. We have flat fees posted on our website, but for a single person, it's $7.95. That includes the trust, the deed. You get a new will with a trust called a pour-over will. You get a durable power of attorney, healthcare surrogate living will. All those documents are included in the package fee. And at the end of the day, there would be a very quick, fast procedure to get assets out of the living trust. They call it a living trust because you create it while you're living, and it's still living when you die, so assets are not in the name of a deceased person.
Okay.
And we can do this very quickly for clients. We can probably get it done in a week or less if we need to. So.
Okay.
And most of our interviews, by the way, what we do is we interview you or mother on the phone or both, and then send you a draft out that day or the next day, and then we can sign it in a few days after you come to the office and you sign the documents that way. So.
Oh. Okay, that sounds good.
Okay.
Could I get the regular number I would call?
Yeah, well, you're in Tampa, so call the 727 number, 586-3306. If you want to send me an email to call you, just send me your name and phone number to Joe by email, joe@attypip.com.
Okay.
All right.
Great.
All right, thank you.
Thanks.
All right. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. The law office is open on this Independence Day, July 4th, 2020. Give us a call at 877-943-9673. That's 877-943-9673. Let's go to Gary in Sarasota. Hey, Gary.
Yes, hi. I got two questions. One, the first one, I guess, is when I took the living trust or whatever this is, let me see here, trust or will thing out with you guys, my daughter was him-hawing about her last name. She had just got married, and so it's in her maiden name, and then she has changed it to her married name now. So, is there any procedure I need to go through to update that, or just leave it ride?
Well, what would happen if you never changed it? Let's answer it that way. Your daughter could have an affidavit that she was married, or whatever the reason was for the name change, and she was previously known by that name, but she's doing an affidavit. She's now known by this name. And as long as your successor trustee knows who it is, because they're the ones handling things outside the court system, it wouldn't be a problem.
What's that mean, a successor trustee?
Well, you when you created the trust, you were the grantor, the creator, the trustee. You own it, you control it yourself. But in your document on the first page, you named a successor trustee.
I did? Okay.
Yeah, you did.
And that would be my daughter, supposedly, I guess.
Yeah, but if you want to change it, we just do a simple amendment. If by some change you never changed it, she could do an affidavit of name change at the time of your death.
Okay, all right. And then secondly, I found a paper in there concerning quitclaim deed.
Yes.
And I just read it. I should have read it a long time ago, I guess. And it just says that any property and all that stuff, it just automatically she has the right to it and does whatever she wants with it.
Well, what a quitclaim deed does is a deed signed by you, from you, to you as trustee of your trust. So what would happen when you die is your successor trustee would record that deed, and then they would be able to transfer it to themselves or sell it.
Yeah, but this little paper that has all that writ on it, is that the quitclaim deed?
Yeah, if it says quitclaim
per
deed in the
se?
top left-hand corner, yeah, that's the second page of it has the legal description.
Oh, okay. All right.
And
I'll
that's what
look
transfers
around
it
for
to the
that, I
trust.
guess. Oh, I see it down there. Okay, where it says who possesses the address of 3309. That's my place. Okay. All right. Well, good. Okay. So I can just call over there and have the guy that's in my area down here in Sarasota. Would that be probably the prudent thing to do so that when things come to an end, she don't have to fumble around with
your documents should be updated every 3 or 4 years anyway.
Oh, really?
So, especially the power of attorney. So we'd be glad to make all those changes for you at once if you like.
Okay, so I'll just get a hold of the guy down here, and he'll just handle it all.
Yeah, Dennis Moses is probably who you use down there. Yeah, Dennis will be glad to help you.
Thank you, sir.
All right, thank you. You're listening to Ask an Attorney all about Florida law. If you have a legal question on this Independence Day, it's 877-943-9673. That's 877-943-9673. Let's go to Julia in Sun City Center.
Good morning.
Good morning.
And happy 4th of July.
Happy 4th of July to you.
Thank you. I have a question. I have a trust that I had been, I think we did about 4 years ago while I was living in Missouri.
Okay.
Now I reside in Florida.
Yes.
Would that trust be still okay?
Well, the answer to that question is maybe. But maybe it might need a change or two to make it work better in Florida. Trusts are different from state to state. So what we do is offer, and we do have an office in Sun City Center, we offer a client a free review of your document.
Okay.
It could be the most you might have to do is a simple amendment saying now you're a resident of Florida, take out all the reference to the state statutes where you've come from and implement Florida statutes into the document to make it work better in Florida. Most likely you need to do a power of attorney in Florida. Healthcare Surrogate Living will have currently dated documents under the Florida statutes on those documents. But the good news is the review of the documents and the recommendation of what you should do doesn't cost you anything. And then if you have to do a few things, then we have a flat fee for each document. So,
okay.
And we do have an office in Sun City Center. In fact, I'll be there Wednesday. I'm usually there once a week, and I'm usually there on Wednesdays. Sometimes it changes, but I am there this coming Wednesday, for example.
What is the address?
We're right on the main drag. We're almost next to the post office there in Sun Center. It's right across the street from the Winn-Dixie, right there on 674.
Okay.
We're in the Pant Financial Center, which is a yellow building right there on the main drag on 674. Yeah.
And who do I ask for?
It would be me.
And your name?
Joe Pippen.
Oh, Joe Pippen. All right. Thank you, Joe.
Thank you.
Thank you so much. All right. Bye-bye.
All right, thank you. You're listening to Ask an Attorney all about Florida law. I'm Attorney Joe Pippen. Happy Independence Day to you. This 4th of July, what a great country we live in. You know, all the problems that go on in our country, we have freedom. And we have freedom, and this is Independence Day. And so many, our history, I think, is just a marvelous history. And there's no place in the world better to live in. So, rah, rah, America. And Independence Day as we all get to celebrate this wonderful country we live in. Let's go to Joe in Largo.
Hey, this is Joe Pippen talking to you.
Hey, how about that? Well, happy Independence Day, Dad. And thanks for your service to our country in the past, too.
Well, you know, I was just tomorrow, July the 5th, your mother and I will celebrate our 76th anniversary. And I got to thinking about that, and we got married, had our honeymoon in Monticello Hotel in Charlottesville, Virginia, and she agreed to marry me because I was stationed there in North Carolina in the Marine Corps, and I didn't think I had any chance of going overseas, and 30 days later, I got my orders to report to San Diego, California, and the South Pacific, where I spent the rest of the war years there. But and that I thought maybe your public would like to hear a little bit about you and where you came from, and that's the reason for our call. And I appreciate all that you have done for the community that you have grew up in, and in Florida here in particular. So you're I'm an old man, but you're a lot younger. But you're a great young man, and we love you and we appreciate you so much.
Well, thank you so much.
And
happy anniversary. I know I saw you yesterday and was able. My wife Beverly made them they're in basically a shutdown situation, and then they're in independent living, but they're still in a lockdown situation. And you're where you have is wonderful in that no one has got the virus. They've really protected all of you very well.
Yeah, there are over 400 people here, and the restrictions are kind of rigid, but the fact nobody has gotten the virus is really a credit to the management.
Yeah, so we hope you enjoy that upside-down pineapple cake Bev made for y'all. So.
Well, you know I am. I'll tell you.
All right.
And, we saved that for tomorrow because it's a special. Your wife was a lovely lady, and the good thing about it is that you and your wife both are Christian people and have been all of your lives. So it's good to have a son like you.
Well, thank you so much, and happy anniversary, and happy 4th of July. All right.
Yeah, have a good day.
All right, thanks.
Bye-bye.
Bye-bye. All right, well, thank you, Pop. Let's go to Karen in Clearwater.
Hi.
Hey, Karen.
My question is, well, there's two. One, I'm selling a home, and they want to put it in the trust name, but I want to put it in a different trust. Am I allowed to do that?
Well, man, you are selling a home, and before you sell it, you want to put it in a trust. I'm not sure if I'm following your exact question.
Okay, well, the home I have right now that I'm selling is in the trust name.
Okay, in the trust name. Okay, I got you.
Okay, and then they want to make the check out to my trust, but I'm buying.
Yeah, well, that would be
okay.
Hold on a second. Did I do your trust or someone else?
Someone else.
Okay, and is the deed recorded in the trust name?
Yes.
Okay, since the deed is being sold out of the trust, it's appropriate for the check to be made payable to the trust.
I can't.
Do you have a? Well, you sold it. There's a contract, so the contract says the trust is the owner. So since the trust is the owner now, because the deed was recorded, the sale of the trust, the check will be made out payable to the trust. But, hopefully you have a checking account or something in the name of the trust. You just deposit it. It's not like you're restricted to the money or anything. It's still your money.
Well, I'm buying another home.
Okay.
And the people that have the other home have a trust. So I'm using the money that I'm selling from the one to buy the other, and I just wanted to have them make the check out to the other trust of the one I'm buying.
No, I think, was it a title company handling the closing papers? They're going to require that the check be made out to the trust. But you can instantly move the money to wherever you want. It's your money. There's no restrictions on you. So I think you might be over worried about something that's not really going to be a problem. You and the trust are the same entity, the same tax number. So once you get the check made out to the trust, you put it in a trust account. You can move it instantly that day to another account. I mean, it's not going to be a big thing.
Okay, then the one that I'm buying, I can just have that put into the trust name immediately.
Yeah, you can buy it.
You can personal name.
Yeah, you can buy it into the trust. Yes.
Okay. All right. Thank you very much.
All right. Thank you. You're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen. If you have a legal question, you have a toll-free number, 877-943-9673. Let's go to Derek calling.
Good morning. My question is, I was just recently put onto the deed of a property that my father owned. Mm-hmm. And he lived up in New Hampshire, and the property was here in Florida. He just recently passed away, and I'm trying to figure out, is the property automatically transferred to me, or do I have to record an affidavit of survivorship or anything like that?
All right, well, it depends on the magic words on the deed, I call it. So if the deed was dad's name, your name, and the magic words jointly with right of survivorship on the deed?
Yes.
Upon his death, they would.
Yep.
Upon his death, it automatically goes to you. Just file a death certificate at the courthouse.
File the death certificate at the courthouse?
Yeah, because that's where the deed's recorded. So if the deed, the deed did not have the magic words jointly with right of survivorship on the deed, then that would be considered tenants in common. And that would have meant that you own half, your dad owned half individually, and his half would have to go through probate. If the deed, if the magic words behind the names are tenants in common, then his half would have to go through probate. If there are no magic words, that's tenants in common and would have to go through probate. If it's jointly with right of survivorship behind the names, then it automatically goes to you, and all you have to do is file a death certificate at the courthouse.
Just file the death certificate at the courthouse, and And there was a mortgage on the property. Do I have to inform the bank that he's deceased or anything?
Well, do you have to? No. Can you keep making payments? Probably yes. A lot of people will tell the bank that he died, and they'll assume the mortgage, and the bank will usually just let you assume it. But people do all kind of various things on that. Some people just continue making the payments because they're concerned the bank won't let them continue the mortgage. Both names. Let me ask you this: if you bought it in both names, did you both assume that? Did you both sign for the mortgage?
No, we did not buy it in both names. Only he bought it.
And then you transferred it to you.
He was the only one on the mortgage.
Okay.
I'm sorry.
So he bought it, and then when did your name get on the deed?
Literally a couple of weeks before he passed away.
I see. That's not totally good. If he had died and left it to you, you would get a stepped up. How long had he owned the property?
He'd only owned it about a year.
Okay, well that's probably okay then.
Yeah,
the cost basis won't be affected. Technically, he should have. His estate technically should do a gift tax return because the value of what he gave you is more than $15,000, and there wouldn't be a tax due, but there was a gift tax form due because of the amount of the value of the gift. But he could elect not to pay a tax and use up part of his lifetime exemption. So unless he had more than $11.5 million, it wouldn't be an issue really of any payment.
Okay. So as far as just taking the death certificate down to the courthouse and recording that, the property will then transfer into my name. But if I can just keep making the mortgage payments without it. I didn't know if the bank was going to basically try to accelerate the loan or something and demand the entire amount of the note immediately or something.
Well, that's the other thing. See, since there was a mortgage on the property just in his name and him being the owner, the bank would have the right to accelerate because he made a gift of the property while he was living to you and added your name. And technically, the mortgage probably states that if that happened, the bank could probably accelerate the loan. So whether they will or not, because now he's died and it was going to be yours anyway through the estate, they may or may not accelerate the loan. Is it a favorable interest rate to them or to you?
I guess to them, it's like 5%.
Well, you might want to seek new financing and get a loan for 3 or 4%.
Right.
And then that wouldn't be an issue.
I was even thinking if I went to sell the property, could I just do I sell it without any impediments there? Am I legally able to sign like a listing agreement with a broker and sell it?
Yeah, you're the owner now, so sure. Then the mortgage should just be paid off at the time of the sale from the proceeds.
Okay. All right. I guess that's what I'm going to do.
All right.
Now.
Well, if you need any other help with any questions you have, feel free to call me. I don't charge for questions. I don't charge people on the radio, so how can I charge people in my practice? This is kind of the way I think about it. So, all right.
That's great. Thank you, Joe.
All right. Thank you. All right. Let's go to Bob in Dunedin. Hey, Bob.
Hello.
Yes.
Hello. How are you today?
I'm doing great. And you?
I'm hanging in there. I'm not in good shape. Look, I'm pushing the 81 mark and been on and off with my former wife for 20 years. And she knew my financial situation when we got married. I have provided, as I did have a little money back then, but then she filed for divorce, and consequently I had to take a bankruptcy. So then she came back, and then she left, and then she come back again, and then she left. And now she came back 3 years ago, and I want to move back in with you. Okay, well, I don't have much. I just have a mobile home. But now she's leaving again. It's just constant back and forth, and I don't know if I have any recourse against her or not.
Okay, so you're divorced, right?
Yes.
Well, what kind of recourse would you be seeking if you had the right to seek a recourse?
Some kind of financial assistance.
Oh, I see. All right, so, but when she wanted... Okay, hold on. When she wanted to come back into your home, she asked, basically to come back as a guest, right?
Yeah.
And you didn't mention rent. You didn't say we're divorced, so you can live here, but you need to help with expenses or pay rent or anything. So that never was discussed?
No.
And then she left, so I don't think you'd have a cause of action against her to pay you anything would be my answer.
But she was paying. She was paying all the groceries, and then she'd give me $1,000 here to pay for this, $1,000 there to pay for that.
But you didn't have... Yeah, but there's no contractual obligation. There was no contractual obligation of her to do that, right? I mean, you didn't get her to sign anything.
No, I didn't.
So, because you're not married, and since she left, I really don't think you have a cause of action.
Okay, buddy.
All right. Now, if somebody out there disagrees with me, and I probably have a few attorneys out there and other people who might have a different thought on it. Hey, I invite people to call in and help me all the time on the show. So if somebody has a different opinion, you might have an implied contract, but they're very, very hard to enforce, and I don't think it'd probably work at the end of the day. So therefore, you'd probably be spending your money based on some implied verbal contract that most likely, I would say you have less than a 50-50 on that one. If you took it to court, and going to court is expensive, and you could 50-50, you could lose too. All right? All right, I guess maybe he left. All right, let's go to Jane in Pinellas.
Good morning,
hey, Jane.
Mr. Pippen. Thank you for your dedication and being there to help people even on the holidays.
Oh, no problem. I love doing my radio show. Now I've done it for 36 years.
Tell.
So yeah,
you radiate your compassion, your concern for the community.
Well, thank you.
My question is, I'll try to be brief, is that for 35 years there was a guardianship for the ward, and I could not really object to it, and someone, not the judge, but someone in the court system decided that the guardianship was not in place, or in other words, it was being discharged. So I couldn't really argue about that. So for 5 years, I am the caregiver for the ward. And the ward has, shall we say, regressed medically. And it appears that there might be the need for a guardianship. And I'm a very reasonable person, but how is it possible to reinstate a guardianship without going through all the policy and procedure to gain a guardianship?
Well, how long?
If I'm making sense.
Yeah, I understand.
The guardianship was released 5 years ago, and I was not in favor of it. But it appears that the person, the ward, is shall we say, he had the opportunity to do everything, but because of medical reasons, there is a need for guardianship again. And I was wondering if it would be feasible to have the guardianship reinstated, or do you start from scratch again with it?
Well, you probably have to pretty much start from scratch. Because the court found, I guess the court approved that no guardianship was necessary. So it was, taken out of guardianship. So now if it needs to be reinstated, you're going to have the two doctors do the examination, unless the person is willing to do a voluntary guardianship. If a person's willing to do a voluntary guardianship, are they able to do that?
Yes, I would think so, because they do very well with ADLs and that sort of thing, but handling, business affairs and the doctors and all that sort of thing. And I just recently had a wake-up call when the person was having, an episode medically. And when I spoke with the primary physician, I am the power of attorney and health surrogate. And I said, well, he's not in a position to be able to speak right now. In other words, he was ill. It would have been pointless to try to have a conversation. And he stated, well, I can't speak to you. And I recognize and respect, what he had to say, whether I agreed or disagreed. But he stated that, well, I need to speak to him. You're not listening to what I say or doing what I say, and I do have a plan in place, a very good plan.
Hey, Jane, if you call me, I'll give you the name of a guardianship attorney outside of our practice that's very good, also in Clearwater, and see if
hopefully financially, I'll be very honest with you. I'm quite elderly and am rather limited financially in this situation.
Does the ward have money?
No, there is no money.
I see.
It's below poverty level.
All right, well, I'll give you a couple of choices. The Clearwater Bar might have a pro bono association attorney. Yeah, but I'll give you the name of the Clearwater Bar and phone number, and give you the name of an attorney that does guardianship for maybe they give you at least
that would be wonderful.
A free discussion for you. All right.
Yes.
All right. Very good.
And you want me to call your office, and then you can give me.
Yeah, or
and
you can.
Could you give me your office number?
Or unless you have email, you want to send me an email if you.
No, I don't do email.
All right. So the office number in Pinellas is 586-3306. And
3306.
Yeah, go to extension 200.
I'm sure there's some resolution to this.
Yeah.
But my interest is to make sure, after all these years, that the board is first.
Yeah. Well, I'll give you a couple of choices there.
Thank you so much.
All right, my pleasure.
For your help.
All right, thank
you. Have a good day.
You too.
Bye-bye.
All right, you're listening to Ask an Attorney, all about Florida law. I'm Attorney Joe Pippen, practicing attorney. We have 10 minutes and 50 seconds and counting here in the show, on this 4th of July, Independence Day 2020. A little time left. Phone lines are open now. If you have a legal question, call me at 877-943-9673. 877-943-9673. Phone lines are open right now. Give us a call. Love to talk to you on this Independence Day. Hey, so I will be doing part of the Drive Time show this coming Monday, 2 days from now. I'll be on from 4 to 6. I will be doing an Ask an Attorney type of show from 4 to 5. From 5 to 6, I have a special interview. It's the primary reason I'm coming in to do this. Very good book called Jesus in the Courtroom. And we're going to be interviewing the author of that book and talking about Jesus. Of course, Jesus was never in a courtroom per se, but he was a big teacher of the law in multiple cases through the Bible. My wife, when I was telling my wife about what I was going to be doing Monday and talking a little bit about that, her response was, all Jesus taught was love. So that got me thinking about that. So we're going to talk about all that, though. Jesus in the Courtroom on Monday during the Drive Time show, Bill Bunkley's show. From 5 to 6, I'll be answering legal questions from 4 to 5, and doing the interview from 5 to 6. So if you or never have listened to Bill Bunkley on the Drive Time show, well, you might check it out a little bit, but I'll be doing the show on Monday from 4 to 6, and looking forward to doing that as well. If you would like to contact our office, we have a toll-free office number. We have multiple stations carrying the program. We have in Jacksonville, we have WBOB. In Haines City, we have WLVF 90.3 FM. We have the Salem Communications, our flagship station. They're on 570, 910, 860, 930. Sun City Center, 96.3 FM, community station there. Multiple stations around Florida carry this program on both AM and FM. And glad for all of you. We have offices in all of those locations, by the way. If you'd like to call our office, we have a toll-free number, 1-800-226-3529. That's 1-800-226-3529, extension 200. If you'd like to email me, it's joe@attypip.com. Let's go to Kathy calling from St. Pete. Hey, Kathy.
Hi there. Morning.
Good morning.
Just a quick call to say thanks for your service, for your work, and also, to hear you and your dad this morning. Wonderful. Really wonderful to hear him. And congrats to you all. That's all.
Well, thank you very much, and happy Independence Day. Thank you so much for calling.
Thank you. You're welcome.
All
Bye-bye.
right. All right. Let's go to Greg in Jacksonville. Hey, Greg.
Hi, good morning. Thank you for taking my call.
My pleasure.
My question is, my mother in Tennessee died in May. She has a will.
Very sorry for your loss.
Thank you very much. She has a will. However, the person named as the executor of the will is not of sound mind. She has some form of dementia. Generally, what happens in the case when an executor is not able to perform the duties of such?
Well, is the executor of sound enough mind to be able to sign a paper to resign and know what she's signing?
I'm going to say probably not.
Okay. Then you need 2 doctor's letters that she's not able to fulfill that job. She's unable for mental or physical or both reasons to perform the duties of executor or personal representative of the estate. So then you submit that along to the court, and then the court will look. Hopefully the will has a successor to that person named. They have a primary and a backup person named.
There's no backup.
Well, then in Florida, I don't practice in Tennessee. So in Florida, the answer would be, and hopefully there's something similar in Tennessee, that the majority of the beneficiaries named in the will could agree and consent to the appointment of one of them, perhaps as the personal representative of the estate.
Okay.
You need a Tennessee attorney to help you with that one, though.
Yes, understood.
All right?
All right. Thank you very much.
Thank you. Let's go to phone lines are open. Might have time for one more call after we talk to Chris. Phone lines are open at 877-943-9673. 877-943-9673. Let's go to Chris in Jacksonville.
Good morning.
Good morning.
So I have a lease with a landlord that has a clause in there for no animals. My wife has we have a dog, but she needed the dog as an emotional support animal, and we went and got a certification. We're waiting for it to come through in the mail or through the doctor. Now, the landlord, when they rented us the property, they did not have an agent, or we did not use a real estate agent.
Mm-hmm.
But the landlord does own multiple, business properties. I'm not sure how many homes they own. Do they have to accept the certification for the emotional support animal?
Yes, if you have the certification, they have to accept that.
So even though they didn't use a rental, we didn't use a real estate agent.
Yes. No, you're entitled. If you have a certification in need of your emotional support animal, they have to accept that.
Okay. 'Cause I'm just reading online that was one of the things that they had an exception for.
What was the exception?
I just didn't understand that we didn't use a real estate agent when we rented.
No. I don't think that's an exception. I don't think that was an exception that would apply to you.
Okay.
So show them the certification and see what happens next.
Okay.
And then if they refuse, they still want you to go and want to evict you, then have an attorney contact them and explain your rights to them.
Okay. All right. Thank you.
Thank you.
Have a good day.
All right. Thank you. Let's go to Stephen in Lakeland. Hey,
yes,
Steve.
sir.
Yes, what can we do for you? We have 3 minutes.
Okay, I'll try to make this quick. Dad passed away, I want to say, about 8 years now. Left a will saying that my stepmom could stay in the house for as long as she lived or for some reason decide to move out. My question is she responsible for the property taxes? Or would it be the executor being my sister and, me? Because me and my sister's name is on the property now.
All right, so so your dad died and his wife is living in the home. Pursuant to the will, it says that she can live there.
Yes, sir.
So a life tenant, that's called a life estate interest, basically.
Okay.
And a life estate tenant has the duty to pay the taxes, maintenance, and upkeep. If the life estate tenant can't do that, then they could leave and vacate the property and basically give up their right to live there, but that'd probably be a legal document that would have to be created.
Okay, so if I understand you right, she is responsible then.
She is responsible, yes. Yes. So she needs to be advised of that, and if she can't do it, she might have to leave.
Okay, and you said we would need a court document for that, though, right?
Well, if she's not going to leave, you might need a court document.
Okay. All right, I'm new to this, so I'm just trying to figure it out. Like I said, my sister's the executor, but anyway, that's where we stand, sir.
All right.
But I appreciate it, really do.
All right. So let's go to Mary calling in from St. Pete. Mary, we have 1 minute and 16 seconds, and I need a little bit more time to close the show. But I'd love to talk to you because your question's about fireworks. What can I do for you?
It is. If everyone's doing fireworks on July 4th and I don't, and it makes a lot of noise, can I put my boombox out and play Paralyzed Veterans of America Presents 4th of July favorite patriotic American songs to celebrate July 4th?
As long as you don't violate any noise
noise violation
in the city, yes.
So like firecracks.
You can give it a shot for a while.
Yeah, thank you very much.
All right, thank you.
Happy
All right.
July 4th.
Thank you. Happy Independence Day. Happy 4th of July. Thank you so much for listening. If I can help you in any way, you have a toll-free number, 1-800. It's my office number now, 1-800-226-3529. Hey, if you want to call my cell phone within the next half an hour as I drive home, I'd love to talk to you as well. Cell phone number is 727-667-3967. Hey, have a wonderful, happy Independence Day. Happy 4th of July. Love America. Best country in the world. You have a great, safe day. Thank you.